right, ordered him not to drive. Just because you think you can drive doesn't give you the right to just go start driving in
Right
violation
off
of a
the
court.
bat, Judge is laying down the law. Literally, just because you feel like you can drive doesn't mean you can legally do it. This is where people confuse freedom.
Judge, you told him not to drive. The allegation is that he was driving. First of all, Judge, I want to speak on when you told him not to drive, it was because the state told you that he had an ALR suspension. But I've got for you, Judge, I couldn't access it at the time as I don't have access to our correspondence. This is an ALR dismissal.
So,
There was never a suspension on his license at all. He's been good to drive.
he was also drinking. The concern was that he was drinking.
Well, Judge, you told him before you left that that you were doing this because there was already a suspension on his license and he couldn't drive. I never got the impression that you were taking that action because he was
With
drinking.
permission. What do you think? Should ignorance of a court order interview too? Okay, this is where things start to unravel. The defense is throwing out dates.
He was drinking allegedly, and the license was suspended. Can you run his license, please, state? Did it just become eligible, or when was it eligible? You know what? Let's do this. I have a line of people. I've got arraignments. Let me put this off a little bit because this is going to take a
I
lot
have
more
to go to the
time.
doctor's office. I sent you an email on Friday when you said this. I'm supposed to be at the doctor. I took today off, and I never got a response that when I asked to move this to tomorrow. So I've got to get it done. I've got to be at the doctor.
So we can do it tomorrow. You want tomorrow?
I'm already
Let me
here.
look at what.
I'm already here. John, it looks like it was looking at 4/2/25.
So what day was it? Look?
4/2/25. My see no license.
And what are the days that he's alleged to be driving?
Looks like Judge, he don't judge.
Does he have an interlock as well?
Yeah, Judge, yes, and you're alleged to be driving on the second of February.
ALR dismissals interlock devices, but the judge, he's not buying it just yet. Notice how she keeps asking for license verification. That's because
More, Judge. The bond conditions that you signed on the 28th, nothing on those bond conditions says he can't drive. My client tells me that when he went to pretrial services, he was told repeatedly, because he asked repeatedly, to drive. So I think pretrial has the apparent authority to tell him what the bond conditions are, especially for somebody, a layperson who, when he goes there, he doesn't.
There is a no driving affidavit on file as of March 28th, where I ordered him not to drive. Just because you think you can drive doesn't give you the right to just go start driving in violation of a court order. You come here, you ask for permission, and then we give you permission. You don't just go do something and ask for forgiveness after the fact.
It's told by pretrial services.
I don't give a damn. Jesus tells him.
Judge,
It doesn't matter. Court order is a damn court order. You just because pretrial services just tells you something doesn't. Really? Is that what it's not coming to?
This was all premised on wrong information that he couldn't drive. He can drive. There's nothing wrong with his license. There was no ALR suspension. No. The state told you that. That's why you.
A suspension.
It's not
And
3. Did you catch that? Pretrial allegedly gave the green light to drive, but the judge is about to throw down.
lifted on.
There was no ALR suspension. I got the case dismissed. It's not possible. I mean, would you like to see the email? The dismissal order, Mr. Jersey? Is this right? That's fine. I'm showing you the suspension. It was the end date 1/3/2025 and 4/2/2025. It's not possible. It was dismissed from prejudice. 6/3/2025. The left date comes in. And if that
So you're wrong. What I'm saying is, based on what I can see,
If there's a dismissal order,
And
then
the
that's
real
suspension.
authority. Here's a lesson. Never rely on second-hand clearance when a court order says otherwise. Would you trust
It's contrary to law, and it's void.
I'm going on what DPS says. I don't have access to what you have. I don't know. All I know is what I don't. Please, you don't need. All I'm saying is that regardless, Mr. Johnson, court order is a court order. You don't just do something willy-nilly because you think you're in the right because of this. No, we have court orders for a reason. If you ever do this again, I will have a contempt hearing. I'm warning you now. And the next time you do something contrary to anything, I'm going to throw you in jail so fast your head's be spinning fast as a wheel. Now,
the clerk interview for? This is the dramatic pivot. The defense insists there was never a suspension. If that's true, the entire premise
you have a CDL, am I right? I'm not going to put you in jail now, but I want to make sure that you're not drinking. So, does he have a scram on right now?
Yes, Judge.
Okay. Everything's operational?
Yes, Judge.
Don't do it again. The only reason I'm not taking you into custody now is because your license was valid on the second. Otherwise, you would be staying with me. Don't violate a court order. We tell you what to do, not pre-trial, not anyone else. Do you understand?
Sir.